Ladies and gentlemen, the Governor, Mitch Daniels. Lieutenant Governor Becky Skillman. Senate President Pro Tem David Long. Majority Floor Leader Senator Connie Lawson. There she is. Majority Caucus Chairman James Merritt. Minority Floor Leader Richard Young. Assistant Minority Floor Leader Vi Simpson. Majority Floor Leader Russell Stillwell. Majority Caucus Chair Dale Grubb. Speaker Pro Tem Chet Dobas. Minority Leader Brian Bosman. Minority Floor Leader William Friend. Minority Caucus Chair Kathy Richardson. On the North Balcony, Mrs. Amy McDonald, wife of Chief Justice Shepard. Ms. Maddie Shepard, daughter of the Chief Justice. Mrs. Mary K. Orr, wife of the late Governor Robert D. Orr. Mrs. Denise Rucker, wife of Justice Robert Rucker. Mrs. Cheryl Sullivan, wife of Associate Justice Frank Sullivan. Mrs. Jan Dixon, wife of Associate Justice Brent Dixon. The Honorable Steve Carter, Attorney General. Mrs. Susan Carpenter, Indiana Public Defender. The Honorable Tim Berry, Auditor of State. Mr. Douglas Church, Indiana State Bar Association President. Mr. Kevin McGough, Indianapolis Bar Association President. To be noted, a classmate of John Taylor, the parliamentarian. Mr. Ryan Gardner, Marion County Bar Association Vice President. Mr. R. William Jonas, Jr., Indianapolis State Bar Association President-elect. Mr. Tom Peters, Executive Director of the Indiana State Bar Association. Mr. Daniel Buba, Indianapolis Bar Association President-elect. Mrs. Julie Armstrong, Executive Director, Indianapolis Bar Association. Members of the Indiana Judicial Qualifications Commission, and Dr. Darrell Yost, Mr. Jim Young, and Professor Matthew J. Barrett, University of Notre Dame Law School. I believe Mr. Barrett is representing the University of Notre Dame Law School and is not part of that Judicial Qualification Commission, although he may be someday, I believe. The justices and judges will now process in, I believe. Chief Justice and escorts, please come forward. The Supreme Court Justices, Justice Brent Dixon. Justice Frank Sullivan. Justice Ted Bone. Justice Robert Rucker. The Indiana Court of Appeals, Chief Judge John Baker. Judge John Sharpnack. Judge Edward Najim. Judge Ezra Friedlander. Judge Carr Darden. Judge Mark Bailey. Judge Melissa May. Judge Margaret Robb. Judge Nancy Vadlik. Judge Paul Mathias. Judge Michael Barnes. Judge Terry Crone. Judge Cale Bradford. It is my honor to present to you now Lieutenant Governor Becky Skillman.
Thank you, Mr. Speaker. Pursuant to Section 3 of Article 7 of the Indiana Constitution, the Indiana General Assembly is convened for the purpose of hearing a message from the Chief Justice of the Supreme Court. Ladies and gentlemen of the House and Senate, distinguished guests, I have the high honor of introducing Chief Justice Randall T. Shepard.
Thank you all very much. Thank you all very much. Thank you. Thank you very much. Thank you. Thank you all so very much. I want to step backwards just a tad. You've already heard him introduced. One of the most marvelous members of Indiana's court system is here today for the last day of the judiciary, as he soon will close out a remarkable career as a lawyer and a public servant, Judge John Sharpnack. Thank you for everything you've done. I'm going to say, because it's the right moment, Judge Sharpnack is sitting in the midst of a team that has itself had a remarkable year. The Indiana Court of Appeals has experienced another 14% increase in the number of cases it's received, almost twice as many as we had at the beginning of the Bayh administration. I'll come next year to talk to you about that problem, but for the moment I think it's adequate to say thank you to them for stepping up to the plate. They've produced more than any year in the history of the Indiana Court of Appeals, and they deserve our thanks. I want to say how much I appreciated what Governor Daniels had to say last night about the work that Governor Kernan and I and our colleagues and the people from IU did over the last few months, and how much I appreciated the warmth of your reaction to his compliment. We hope that this will be time well spent for Indiana. But as respects this afternoon, those remarks are as much obligation as accolade. You can't spend time suggesting to others how they ought to reform their work in their own bailiwicks without being serious about whether you're doing what you ought to be doing in your own backyard. And so I'm going to talk today about what we in the courts have changed and what we can change to provide more thoughtful and expeditious justice to the 6.3 million people who call Indiana home. And in thinking about that, I've been especially impressed by the many ways in which Indiana courts are seeking to serve better by embracing technology. It is, in many ways, the story of the era in which we live, in many ways, a story about the generations. My grandmother used to tell me about the day that electricity came to the town where she lived, and my daughter has no memory of the day before laptops. It is remarkable to stand really having known people with those two experiences. But this will not be a report about bytes or bandwidth. Instead, it will be about what we can do that actually makes a difference in the lives of people. For example, what can we do to be better at combating the scourge of domestic violence? Now, there are many of society's institutions at work on this front, from police officers to prosecutors to social workers to social agencies to people who sponsor shelters. And to be sure, the court system does its part by meting out punishment after the fact through criminal prosecutions. But on the prevention side, one of the leading tools is the protective order, which seeks to keep separate the potential abuser from the potential victim. When a woman or child is threatened by an abusing boyfriend or an ex-husband and a patrolman answers to a call of domestic disturbance, when that moment of truth is at hand, how does the officer sort out the situation on the scene? Should the boyfriend even be there at all? How does the officer know whether the boyfriend is there in violation of a protection order, subject to arrest under criminal statutes that you've toughened up in recent years? And it used to be that the officer could only learn that, could only verify the existence of a protective order by calling the clerk's office. And that only worked if the disturbance, the confrontation occurred during regular business hours. And these gaps in information sometimes resulted in human tragedy. But soon, every officer in the state will be able to access every protective order in the state around the clock and virtually from the moment it is issued. We are more than halfway through installing a statewide protective order registry that immediately sends these orders directly to the local police, to the local sheriff's department, enters them into the databases of the state police and the FBI for good measure, so that responding officers can act on them on the scene at the very moment when they need to be acted on. There is no doubt that this change made possible by technology will literally save life and limb for women and children. And so it is with drunk driving. When the police arrest somebody for drunk driving and that person appears in court, the judge suspends the license pending trial. But from time immemorial, the news of that suspension went from the county courthouse to the Bureau of Motor Vehicles by sending paper through the mail. 10,000 of those arrived across the street every week in the Bureau of Motor Vehicles. You can handle the volume, but not the time. The fact that it went by paper meant that it was weeks before the suspension showed up in the computers. So it was literally possible for the judge to suspend somebody's license in the courtroom, have the defendant walk out into the court parking lot, get back in his car, and head for the tavern. If he got stopped because he had a taillight out or something, the stopping officer would look, check the license in the computer. The computer would tell him the license was in good standing, and he'd give him a citation for the taillight and let him go on to the tavern. By the way, it could happen in the opposite direction, and actually did once. A guy goes to trial. The jury finds him not yet. Representative Bosma's figured this out way ahead. It can happen the other way. Goes to trial, gets found not guilty, acquitted by a jury of his peers, gets stopped on the way home. The police officer looks up and says, "Hey, you're driving on a suspended license. I'm going to take you to the jail." The fellow says, "Wait a minute, I just came from my trial. I got acquitted." Tell it to the judge. He's going to take him back downtown because of that information gap. And as recently as, I didn't make that up, as recently as 2 years ago, this was exactly the sort of thing that could happen in most places in Indiana because the orders went to Indianapolis by hard copy. And now, as of the end of December, 95% of the state's courts send that information by computer directly to the Bureau, directly to law enforcement agents, and there's no doubt that people who would otherwise have been the victims of drunk driving are alive today because of this reform in court information. And so it will soon be with another kind of tragedy. We all of us cringe on those occasions when a trooper or a local law enforcement officer is injured or occasionally even killed while writing a ticket at the side of the road while people go down the highway at 50, 60 miles an hour. Within the last few months, we've launched an electronic citation system that uses handheld equipment like the equipment you see in a car rental agency. The officer can swipe the barcode on the back of a driver's license and write a ticket in 5 or 6 minutes rather than handwriting it in 15 or 20. Until now, we're handwriting 700,000 traffic citations in Indiana every year, and that won't happen anymore. As the result of a collaboration with the state police, the Bureau, the Criminal Justice Institute, the judicial branch, the General Assembly has supported this project by making changes in statutes that allowed it to happen. There's been marvelous collaboration between the executive branch and the courts. There can't be a state anywhere where the three branches work in closer harmony on projects like this, and because of that, we'll get those officers and the drivers off the shoulder and out of harm's way faster than ever, and we're going to read fewer of those stories tomorrow than we've read before. In a very different field, people who experience disintegration of a family rely on courts in a host of ways. To name but one, families, mostly women and children, face hard times until they can get into court and obtain an order for child support. Our child support guidelines have helped move that along because it means the lawyers who handle divorce cases can make an early and better prediction about just what sort of support the court will order, most likely given family income and needs. What's new is that parents can now calculate that for themselves over the internet. Yesterday and the day before and the day before that, 800 people a day in our state did exactly that. It promotes settlement, it reduces litigation, it saves time, and ultimately translates into faster help for children in need. That's a good story about simplification. But there are still lots of things that are confusing and difficult for people who are working their way through the court system, and I'll mention just three. How do people summoned for jury duty know exactly where in the courthouse to report? If you want to file a small claim on your own, how do you learn how to do that? And if you forgot your hearing date, how do you find out when you're due in court? Well, people who go to the courthouse now can find their way through virtual courthouse tours, so far available in 21 counties. It's an internet program that allows you to walk through the courthouse with actual photographs of the interior and room numbers so that you can find your way when you get there to the right room as quickly as possible. Or if you need to file something on your own, the Indiana court web pages will show you how to complete certain simple transactions like uncontested divorces or child support or name changes. We supply these free standard forms for those kinds of straightforward legal matters, and last year our fellow citizens downloaded 525,000 of them before they went to court. And as for problems about forgetting your court date, we're on the brink of something much bigger and much more far-reaching, a 21st century case management system that connects all Indiana courts to each other and to state agencies that need and use court information. And 2007 was a watershed year for that. 3 weeks ago Monday, 10 Indiana courts, 9 in Monroe County and the Washington Township Small Claims Court in Marion County, began using a new system. It's called Odyssey. It provides internet access to all manner of case information, scheduling, motions, court rulings, financial calculations made by clerks, nearly everything you want to know about the 1.8 million new cases filed in our state each year. Turning on this system for testing by real-live court personnel reflected years of work by everyone from judges to clerks to prosecutors and, of course, experts in technology. And it will vastly improve the work that we do in sentencing criminals, in administering estates, in collecting taxes, in pursuing child support, and all the other things that people rely on courts to do for society. We called December 17th the go-live date, but this was not just about pushing a button. As Judge Ken Todd of Bloomington said to me last week, only when you see a change of this scale in action can you begin to appreciate the size of the effort required. And this massive undertaking has many hands on the lever, especially leaders like Lily Judson and Mary Dupree and others supporting our state court administration and our Judicial Technology and Automation Committee, people like Paul Mathias and Jeff DeWan and Andy Kane and Donna Edgar and John Kellum and Mary Wilson, our lead contractor, Tyler Technologies, represented here today by Kristen Wheeler, and the Daniels Administration's Office of Technology, the many members of this body who have carried or supported bills to help make this happen. The heroes in Monroe County include Chief Judge Ken Todd and his colleagues, the county clerk, Jim Fiedler, the prosecutor, Chris Gall, and in Washington Township, Judge Kimberly Brown of the Small Claims Court. And finally, the individual whom everybody involved recognizes as having supplied the vision and the acumen and the monumental commitment to make all this happen, Justice Frank Sullivan, Jr. Won't you stand up, and would you all stand up and thank you. I used the word heroes a minute ago, though I don't tend to talk that way, because we don't call these pilot courts for nothing. These partners are working out the kinks for everybody's benefit. It is the most massive venture in the history of the Indiana court system, and the benefits to our citizens, I am confident, will exceed even the many we can already identify and describe. But there are a host of other initiatives, many at the state level, many at the local level, some using technology and others not, that reflect a court system with reform in its heart. In Steuben County, a story about a new use for very old technology. In Steuben County and many others, an automated telephone link advises jurors if their trial is still on schedule. So if it's not, they can go on and go to work rather than trudge down to the courthouse only to find that it's been settled or postponed. In Indianapolis, a GPS system called Sentinel protects domestic violence victims before and after trial. The defendant and the victim, or the alleged victim, both receive a handset similar to a cell phone, keyed to the areas where the defendant cannot visit. And if the defendant does come near the victim, an alert warning goes off. The people who wear these know you don't fool GPS. It's only happened once in 4 months, and that person was arrested in 31 minutes from the time the alert went off, because they know where to find them. In Noble County and others, television or the internet link the courthouse, the jail, and many DOC facilities so that arraignments and conferences and hearings can be conducted without deputies and others moving around the county or around the state. The Hendricks County courts are about to open a work release center with space for education, for substance abuse counseling, saving taxpayers because the inmates pay to serve there and because it frees up jail cells and beds at DOC. Marion County has devised an interactive system to handle the, count 'em, 10,000 probationers a day, obliged to call in and see if they are one of the 500 randomly selected to take a drug test tomorrow. There is no excuse for forgetting the number, 327DRUG, and we're not going to hear anything about not remembering the telephone number, and that's why you didn't come in. Problem-solving courts represent a new technique of intensive intervention in specific problems. Vandenberg and Du Bois and Monroe and 25 other counties now have drug courts. A recent independent study of the drug court in Monroe County showed a 66% reduction in recidivism. Madison County is planning a reentry court based on the model invented in Fort Wayne that helps inmates reintegrate after returning from prison. Benton County and scores of others take our nationally recognized jury pool list now on compact disc. They feed it into their own databases, and they reach more than 99% of the people who are eligible for jury service. Our judicial conference has launched an initiative to plan ahead for how courts will be ready for the retirement of the baby boom generation. We've begun offering county clerks a jury management system for use in the 2,000 jury trials we conduct each year. We signed on to be your partners in the Indiana Channel and published and posted a host of materials to promote the study of civics and citizenship in Indiana's schools. In Lake County, with help from JTAC, a new management system for cases is upgrading the operation of city and town courts. The Lake County Clerk's Office has introduced online payment for traffic violations, and Lake County will soon become our first county to begin electronic filing. We're about to pilot plans for operating local courts after disasters like tornadoes and floods. And just a few weeks ago, we celebrated the 10th anniversary of a program that's received magnificent support from a series of governors and from this General Assembly, Indiana Clio, that helps minority and other disadvantaged students become a part of the legal profession. And just last week, I knew that Ohio had done the same thing after you did, and that Kentucky had done the same thing, and that Georgia had done the same thing. And last week, I learned that New York decided to do the same thing. They call it New York Leo, not Indiana Clio, and at least they have the decency to admit where they got the idea. And I think that's a pretty good arrangement. We're working at recruiting and training a record number of volunteer advocates for abused and neglected children with the legislation that you gave us last year, and with a remarkable boost for thousands of volunteers from the Indiana Retired Teachers Association. We're modernizing the code of ethics that lies at the very core of our profession. Indiana lawyers and judges spent 27,000 hours last year in classrooms studying how to do the right thing. We've quadrupled in the last decade the number of trained mediators who help people resolve their disputes without the cost of litigation. And last year established a new record number of counties where domestic mediation is available to people who can't afford it for free. We devised a new system that will assure felons on probation who move from one county to another will be supervised by somebody who can watch them in the place where they now live and work, and not by somebody who supervises them from 2 or 3 counties away. In short, this is a judiciary with reform in its heart, its feet on the ground, and its mind focused on its customers. I thank you for helping us make it so. And that is the state of your judiciary. Thank you for having me. Huh? Thank you all very much.
Make us proud.
Thank you very much. All right. Thank you. I'll trade places with you. Thank you all very much.
The joint convention is now adjourned.
Yeah, Brian. House will come to order. Committee announcements. Committee announcements.
The Committee on Labor and Employment will meet at 10:30 a.m. on the 17th, tomorrow, Thursday. That is a time change. Discussing House Bills 1213, Occupational Health and Safety Training, House Bill 1089, Fire Sprinkler Contractors and Installers, 1269, Employee Classification. That's Labor and Employment tomorrow morning.